Start. The plaintiffs took up the matter in second appeal to the High Court, Patna, serial number 1500 of 2019, and there, for the first time, an objection was taken by the stamp reporter to the valuation in the plant, and after inquiry, the court determined that the correct valuation of the suit was rupees 9980. Stop. The plaintiffs paid the additional court fees required of them, and then raised the contention that on the revised valuation, the appeal from the decree of the subordinator judge would lie not to the district court but to the High Court, and that accordingly service number 1500 of the 2019 should be heard as a first appeal, ignoring the judgment of the district court. Stop. The learned judges held following the decision of a full bench of that court in Rakesh Singh versus Suraj Tiwari that the appeal to the district court was competent, and that its decision could be reversed only if the appellants could establish prejudice on the merits, and holding that on a consideration of the evidence no such prejudice had been shown, they dismissed the second appeal. Stop. The matter now comes before us on special leave. Stop. It will be noticed that the proper court to try the present action would be the subordinate court, Madras, whether the valuation of the suit was rupees 2950 as given in the plant, or rupees 9880 as determined by the High Court, but it will make a difference in the forum to which the appeal from its judgment would lie, whether the one valuation or the other is to be accepted as the deciding factor. Stop. On the plant valuation, the appeal would lie to the district court, on the valuation as determined by the High Court, it is that court that would be competent to entertain the appeal. Stop. The contention of the appellants is that as on the valuation of the suit as ultimately determined, the district court was not competent to entertain the appeal, the decree and judgment passed by that court must be treated as a nullity, that the High Court should have accordingly heard service number 1500 of 2019 not as a second appeal with its limitation under section 100 of the Civil Procedure Code, but as a first appeal against the judgment and decree of the subordinate judge, Madras, and that the appellants were entitled to a full hearing as well on questions of fact as of last. Stop. And alternatively, it is contended that even if the decree and judgment of the district court on appeal are not to be treated as a nullity and the matter is to be dealt with under section 11 of the Suits Valuation Act, the appellants had suffered prejudice within the meaning of that section, in that their appeal against the judgment of the subordinate judge was heard not by the High Court but by a court of inferior jurisdiction and the District Court of Madras, and that its decree was therefore liable to be set aside, and the appeal heard by the High Court on the merits, as a first appeal. Stop. The answer to these contentions must depend on what the position in law is when a court entertains a suit or an appeal over which it has no jurisdiction, and what the effect of section 2 of the Suits Valuation Act is on that position. Stop. It is a fundamental principle well established that a decree passed by a court without jurisdiction is a nullity, and that its invalidity could be set up whenever and wherever it is sued to be enforced or relied upon, even at the stage of execution and even in collateral proceedings. A defect of jurisdiction, whether it is pecuniary or territorial, or whether it is in respect of the subject matter of the action, strikes at the very authority of the court to pass any degrees, and such a defect cannot be cured even by consent of parties. If the question now under consideration failed to be determined only on the application of general principles governing the matter, there can be no doubt that the District Court of Madras was coram non judice, and that its judgment and degree would be nullities. The question is, what is the effect of Section 11 of the Suits Valuation Act on this position? Section 11 enacts that notwithstanding anything in Section 578 of the Code of Civil Procedure, an objection that a court which had no jurisdiction over a suit or appeal had exercised it by reason of overvaluation or undervaluation, should not be entertained by an appellate court, except as provided in the section. Then follow provisions as to when the objections could be entertained, and how they are to be dealt with.